Good morning.
Welcome to our Lunch and Learn at Kent, Washington this month for November. We have a great class today on eviction law by Maranowski Law. We'll be presenting in a few moments. Before that, though, however, there's one key portion I want to state for the President's Year. Linda is going to come and talk to you about the Kent, Washington STARS program that we have for the upcoming year. We'll give her a moment to do
Well,
that.
it's not STARS program, it's actually L's for Elders. And so it's that time of year again where we want to give back to our community. And this was our 4th year working with L's for Elders. We have elderly people who are at nursing homes that need something during the holiday season. And so if you would, we have stars, and on the star is the senior's name. This is Patricia. Patricia wants a nightgown and a sweater, size large. So this is giving back to them. So what we ask is you come take a star or 2 or 3 and go out shopping. Put the gift in a gift bag, little tissue. Don't wrap it, just in a gift bag. Staple the star and bring it back to us by December 1. So we have about 150 stars left in the office. So please, if you would, help us out with that donation for a senior. It will make them very happy. So thank you.
Thank you, Linda. Our sponsor for the lunch that you're all enjoying right now is Guild Mortgage. Danny Ortiz is here from Guild Mortgage to speak about his company. Give him a few moments just to listen up before we have the presentation. Danny?
Thank you. Good morning, everyone. How's it going? Thanks for being here and Kent County for having us over. Just want to quickly say I work with Bobby K. Roos. I see some familiar faces here today. We are located in Warwick, Rhode Island. We are a lender. We deal heavily with FHA, VA, conventional, but we do a lot of first-time home buyers. That's our bread and butter, really. And in this marketplace, I'm sure you all know, it's a tough market to deal with. We are one of the few lenders in the state who are delegated Rhode Island housing lender, meaning we do everything in-house from the underwriter down to the closing until we move that loan over to Rhode Island housing. So our turnaround times for Rhode Island housing are just as fast as if you were doing a conventional loan or an FHA loan, right? We actually do carry HELOCs and HELOans, which are being utilized a lot in the marketplace right now. We have access to that. We are actually doing, who here knows what an ITIN number is? ITIN, do you know? Yeah. There is a lot of need, there's a niche in the marketplace for people who file taxes using ITIN numbers. Not every lender does that. We do. We have access to a program that people can utilize as low as 15% down to buy a home, which is pretty big. Again, it's a niche, but we do have access to that. We do have a lot of programs. I'm not gonna bore you with it because everybody knows the programs that we carry. But I think it comes down to we make sure that we are treating clients and giving them this treatment the same way that everybody deserves. So other than that, thank you for your time. Nice and easy. Enjoy the class. Thank you guys for coming.
Thank you. All right, our presenters is here. Are you both presenting? Is it going to be?
No, I'm going to be the main presenter, and then John will kind of be here. Helps.
You guys go back and forth like the Muppets, like the old guys.
It's something like
Kind of like that.
Yeah.
Moral support.
I like the idea. Brian Kaiser and John Sheehan of Maranowski Law will be presenting the class for you today on eviction law.
Yes.
Yep.
Oh, it's not bankruptcy?
Huh? Oh, you got the wrong one again. Go back into the folio. Questions are allowed to be asked during the process, so you don't have to hold off. We will have a question and answer too as well at the end. So if you do have something else you want to bring up, you're more than welcome to. But I do bring up the gentleman from Maranowski to go ahead.
Thank you. Yeah. My name's Brian Kaiser. I'm the shift over here. My notes over here. So I'm the managing attorney for the New England office for Maranowski Law Group. John Sheehan is with me as well. He's one of our attorneys. He handles a lot of the closings on the real estate side of things. So you might see him around and deal with him. We're going to do our best to try to make the wonderful world of evictions as entertaining as we possibly can today. I've been doing evictions for about 13 years. I mean, literally since I was still in law school, I've been doing evictions, so I'm kind of used to going to court and being looked at as the black hat. So me up here smiling and joking about it, I mean, you have to do your best to look at it in as positive of a light as you possibly can. Otherwise, evictions is kind of one of those topics that, depending on which side you're looking at it from, it can be kind of depressing. So I'm going to do my best to try to keep you guys as entertained as I can. Just to start off, I've got a presentation that's all set up to kind of go the overview of everything, a few things to specifically touch base on how it's going to come into play into your worlds every day. But I also want you guys to know, interrupt me at any point. If you have questions, this time is to benefit you and to educate you as much as we can with regard to evictions. So if this entire presentation turns into a Q&A, that's fine. I'm going to let everyone in the room kind of steer how you want this to go, because I really just want to benefit you as much as I can. I am not cool enough to not be interrupted. So believe me, raise your hand, interrupt me, it is totally fine. Like I said, I just want to get the most benefit to everyone here that I can. In a second, John's going to kind of give you the brief overview of what we're looking to touch on in the general presentation. Just, I guess to start off with, we'll start off with a very far-fetched hypothetical. Just kind of bear with me when we go through this. Imagine you're a real estate agent, right? Off to a good start. And your client comes up to you and says, what are we going to do about these tenants? You guys have never heard that before. So everybody's dealt with this at some point, right? So like I said, this is really for you. So if I go over any points that you need further clarification on, or if you have a real world situation that you want John and I to kind of opine on and try to help point you in the right direction, that's what we're here for. So whatever it is that you guys need, this is all for you. In terms of the presentation, the first thing I want to go over is UPL, which is what's the acronym for unauthorized practice of law. So there's a very fine line that you have to kind of consider on a day-to-day basis of helping your client, going to the end of the world to do everything you can to help your client, and also going over the line in terms of what Rhode Island law is going to allow you to do. You don't want to go over the line to where you're actually giving your client legal advice and directing them how to do an eviction. It's fine to tell them the general overview of what the eviction process is, what they can likely expect in an eviction process, but to actually direct them, you should do A, B, C, and if the tenant responds this way, X, Y, Z, don't get caught doing that. There's definitely value to helping your clients, getting them going in the right direction, but when they start asking really, really detailed questions as to, I've got this crazy situation going on, what do I do, how do I get them out? When they start asking you, how do I get them out, the first thing that should really be going through your head is, how do I get an attorney involved? And that's really, I'm not up here as an attorney trying to, anytime somebody asks you a question, give me business. That's not it at all. As a matter of fact, on most of these residential landlord-tenant evictions, we actually refer them out to other attorneys where that's their bread and butter. But I'm bringing this up to where when you hear that question, you want to protect yourselves without dispensing legal advice. If you start answering questions about what do I do, how do I get these people out, you're going to put not only yourself at risk, you're going to put your brokerage at risk. So the possible penalties that you're going to deal with if you do cross the line, and heaven forbid you get put in front of the board and they start actually grilling you and going after you. Possible penalties are loss of license, which nobody wants. It's our bread and butter. Fines, loss of commissions, potential lawsuits, which we all know are expensive and take a ton of time, and potential criminal liability, depending on what you do. Because in Rhode Island, under Rhode Island law, unauthorized practice of law is actually a criminal offense. So no one wants the burden. Your jobs and your days are hard enough. Nobody wants to deal with anything more on top of that. So again, I'm not trying to preach at you, saying anytime a legal question comes up, get an attorney, but think of it when they ask you these questions, just protecting yourself, and just making sure you're armed with the right ammunition to where you can protect yourself and help your client at the same time. That's the biggest thing. Another thing too is if you do kind of start straddling the line in terms of client wants this, and you give them the advice that, okay, if you send this notice, they'll probably get out in 14 days or whatever it is. So what's going to happen on the 15th day, the 20th day, when it's not happening? They're going to blame you. You don't want that. I mean, it's so much of my industry and yours is word of mouth. You want to do a great job. You want to, under-promise, over-deliver to your clients. You don't want to be put in a position to where you're giving them advice and you're giving them an estimate as to how long it's going to take to get whatever part of the process done, and then that just blows up in your face. So there's professional and practical reasons why you just want to make sure you're not crossing that line. And any time that anybody has a question on something like that, if you kind of feel like you're in the gray area, you're not sure whether to answer it, whether or not, what advice you can give, feel free to reach out to me. And again, I'm not asking for a referral, but I'm here, I've got my business cards and John's cards up at the table up here. I'm here to help you. I can help point you in the right direction. And again, I'm not trying to solicit anything. I want to be a resource for you to help you so that you don't feel like anything that you're doing is putting yourself or your brokerage at risk. Because at the end of the day, that's the important thing. So that's the big key here. Well, another point that I wanted to mention too is if you're representing a client, buyer or seller, and an eviction is on the horizon, and the title owner is or is going to be an LLC, it is mandated by Rhode Island law that the LLC be represented by an attorney. You can't even have the managing member of the LLC go to court and represent themselves. It's what's called a jurisdictional issue. If that happens, the judge won't even hear the case, and they will literally continue it indefinitely until the LLC, that member, retains an attorney to represent them. And that's Rhode Island law. That's just how that works. So anytime you see an LLC involved and an eviction question comes up, the best advice you can give them is tell them to make sure that they get an attorney to represent them. As you'll see as we go through the presentation today, there's a lot of different technical aspects to an eviction. Literally from the first notice that is sent out to how questions are being asked in court, what you're trying to get on the record in order to get an eviction judgment. It's very, very hyper-technical. Any misstep along the way can result in the case being dismissed, potentially judgment for the tenants, and when there's judgment to enter for the tenants, that prolongs the process even longer. It's kind of like a Pandora's box of potential issues. So that's something you want to consider whenever something like this comes out. Any questions so far? Okay. So the next issue we're going to talk about is just generally the obligation of good faith. Without getting into reciting a statute, definitions, and all of that, good faith is pretty much common sense. You don't want to not disclose any information to the other agent, to the buyer or seller, depending on which side you're on. It's mainly transparency. Good faith and fair dealings with the other side, it's kind of just built into what the term is itself. So generally speaking, we've got the statutory citation up there, honesty in fact in the conduct of a transaction concerned. It's just common sense. Don't try to outsmart the other side and keep information that you know is important, and you'll just use it down the line like you're in court and Matt Locke brings in the surprise witness. That's not how the real world works. So you want to make sure that you're dealing with everyone, and this is general advice, in a transaction using good faith. If you don't, and you're in front of the judge, and the judge determines that your client did not act in good faith, we'll just say that the court does not look favorably upon that. So that can definitely have some long-term effects. Adverse judgment, you won't get everything that you want. There's a whole set of issues that can stem from that. So generally speaking, and I know you all practice this on a day-to-day basis anyway, but just make sure that you're keeping the obligation of good faith in mind whenever we're talking about an eviction. On the next slide here, so the Landlord-Tenant Act is Title 34, Chapter 18 of the Rhode Island General Laws, and all the subsections go through and define exactly what can and can't be done by landlords, by tenants, what needs to be in a lease, material breaches of lease, which we're going to get into that in a little bit. That's generally the, I guess, quote-unquote Bible for landlord-tenant, any kind of issues in Rhode Island. The Landlord-Tenant Act this is going to apply only to a rental agreement that's involving public housing or any type of federally subsidized or regulated housing, and then there's exceptions. The exceptions generally are buildings, land owned by the government, things that you would not think as a regular residential piece of property. Rental agreement, as simple as it might seem on the surface, that probably includes more things than you're actually thinking. When you use the term rental agreement, I think most people probably think of it as a written lease. You got to have your four corners of your document signed by everyone. That's not necessarily the case. A rental agreement can be oral, too. It can be an understanding whenever there's consideration, which is typically rent, paid by one party to the other to allow them to live in a particular area or a particular unit or house. That can be deemed a rental agreement under the law. So it encompasses a little bit more than you would think. Where are we? Okay. So getting into the difference between landlords and tenants generally, as common sense as that might be, landlord has to be the owner of the property. It can also, depending on how certain disclosures are made to tenants, legally that can also encompass the property manager. Because if certain disclosures are not made when a lease is first brought up, the property manager can actually be on the hook in terms of being a authorized agent on behalf of the landlord, which means more than just speaking on behalf of a landlord. It also means that they're also obligated to accept service and process in the event of a court case. It's a lot more obligations than just simply a property manager would be when certain disclosures aren't made. Tenant is anyone who's entitled under a rental agreement to occupy a dwelling to the exclusive rights of others, or to the exclusion of others. Again, kind of common sense, but this can encompass a few more situations than you would think. One such situation, which we're going to get into as we go here, but I know squatters is a situation that comes up fairly frequently in your world. As contrary to common sense as it would seem, squatters have a lot more rights than you and your clients would probably like. As we go through, I'm going to break down the different types of tenancies that can be out there, what notices are required to terminate those tenancies. But squatters, you can't just simply call the police, as I'm sure as you all know, say we have squatters in the house and they come and just take them out. What's going to happen if some of you don't have experience in this, you'll call the police will come out. Inevitably, the squatter's going to say, well, I have a lease, I have some kind of agreement, whatever reason it is they make up to be there. And then the police officers are going to turn to you and say it's a civil issue. It's got to be handled in court. And that's where, at that point, you ideally want to get an attorney involved to work with the landlord and make sure proper notices are sent out, make sure that squatters' rights, which I know seems like an oxymoron, but make sure their rights are not infringed. Because when you start being forceful and you start trying to do what's called a self-help eviction, that's where we kind of come back to the whole good faith idea that we were just talking about, and the court's just not going to look favorably upon that. Yes?
So what is the difference between someone breaking and entering and being a squatter? The amount of time they're in there?
Well, it's going to depend on when the police get there. It's going to depend on if there's a witness that can actually see if someone broke in. And honestly, it all gets down to what you can prove. If you are living in a property and you go to dinner, you come back and there's somebody in your house, you can prove through documents you live there, you own it, you didn't vacate, all of a sudden this person's in. That's a lot different than if there's a vacant apartment and then the next thing you know during an inspection, all of a sudden there's people in there. common sense dictates, yep, they obviously, breached the lock, it was a breaking and entering, but you can't prove that. There's no way to prove that.
They didn't give them the key.
Sure, and right, logic, that's kind of how normal people would function in terms of logic, but that's not gonna hold up though. Because what's gonna happen is, every single time the situation is, okay, I didn't give them a key, magic? How'd they transport in there? And they're going to say, every single time, well, I have a right to be here because of whatever made up right they make. And at that point, yeah, right, and at that point, it's their word versus yours or the landlord's. And the judge, there's really not a whole lot a judge can do in that position, other than try to negotiate some sort of relief for both parties that works out. And I will tell you, as reasonable as the Rhode Island judges are, and they are wonderful if you're ever in the situation where you're in an eviction in court, they don't want to be put in that position either. It's the best way to get an eviction in front of the court is to have just everything lined up, have your notices that are correct, that terminate a tenancy on a certain date, they don't leave on that date, you file your complaint, and that is what it is. It's very mechanical. Evictions are supposed to be very mechanical in nature. Whenever you start bringing in ambiguities, gray areas, things like that, it makes it more difficult for all the parties involved. And as much as we want, the judge up on the bench to essentially be the god of that room, and say, okay, you're gonna do this, you're gonna do that, they don't want to be in that position either. It's much, the easier you make the judge's job, more than likely, the better outcome you're likely to have, is typically how that works. Any other questions? Okay. So, we've got, I think on slide 7, John, we've got, so this is a list of all the items that are not governed by the Landlord-Tenant Act. So you have, these all kind of make sense in terms of the general definition I gave you. So residence at an institution, occupancy under a contract of sale of a dwelling or unit, the property of which is a part, occupancy by a member of a fraternity or social organization, transient occupancy, boarding houses, things like that. Occupancy by a paid employee of a landlord, and that can get pretty technical in terms of, that's typically in the form of a property manager. And depending on how granular you get into it, it depends on how many units the property manager is managing. I think it's 11, if I remember correctly in the statute. Also, I'm not trying to bore you guys either. I don't want to get super granulated in these details and make you guys fall asleep. We've got, and I don't know if you can see through the podium here, depending on your angle, but we've got occupancy by a holder of a proprietary lease in a co-op, commercial leasing, and resident as a transitional property or housing facility like a halfway house. So those are all situations that are not governed by the Landlord-Tenant Act. Those are also likely all situations where if they arise, common sense would probably dictate to you, it's not gonna be cut and dry. You're gonna want a professional involved to help you out with that. I could be wrong, but I'm guessing you guys aren't dealing with halfway houses and fraternity houses, maybe fraternity houses depending on the part of the state, but these types of things you're not seeing on a day-to-day basis. So the point of that slide was kind of to remind you, if you do see that, red lights should be going off in your head. Get an attorney involved so that way you can make sure that you're doing it properly, because it's the, I'll say, normal process, which I know we haven't even gotten into yet, does not apply to that list over there. Multiple types of evictions here at a really 20,000 foot overview level. You've got no fault evictions, you've got for cause evictions. No fault evictions can be if the landlord, say you represent a buyer buys a house, they want to occupy the property. They can proceed with a no fault eviction. Their reasoning is just simply, I own this property, I want to occupy it now. If there's a situation where they need to evict a tenant because they need to upgrade, remodel a bathroom, rooms, whatever, that can also fly for under no-fault evictions. Yes?
So Brian, the owner prerogative, no fault, even if the tenant has a lease, they can move forward with an eviction?
No, so that, and I appreciate that question because I don't want to, like I said, get into nitty gritty detail without somebody actually wanting to do that. So when you have a lease that is still valid, you're in the middle of it. At that point, you can't terminate the lease for no cause unless there's actually a provision of the lease that allow you to do it. I don't recall seeing a lease that actually has that provision built in. And if an attorney reviewed it on behalf of the tenant and it was there, if I represented the tenant, I would insist it gets removed. Because that essentially allows the landlord to do whatever they want when they want, when you have a valid lease. If that lease is expired, even if it's by a month, that's a completely different conversation. They can do that on an expired lease. Typically, and we're going to get into that as we go, when you want to terminate a lease that's still in existence, hasn't expired yet, the reasons that you get into an eviction are more the for cause. Contractually, you have to have a breach of the contract. So reasons like non-payment of rent, material breach, which we're going to get into, which can, laundry list of things, can be a material breach. But it can't just be fly landed on your wall, I want you out. Like it doesn't work like that. So it's all going to depend on the validity of the lease and the circumstances. And again, that's kind of circling back to what I was saying at the beginning. It's a very, as simple and straightforward as evictions seem, it's kind of a hornet's nest of different issues and complexities that can shape how, what, and why you can do it. So that's kind of why I'm just trying to implore on everybody, make sure whenever situations like this come up, just even if you're not referring an eviction out, just consult an attorney, just make sure you're on the right path and that everything's going as it should. Yes?
Quick question.
Sure.
So, say someone has a multifamily.
Mm-hmm.
They have someone with a lease, but they're selling that multifamily.
Mm-hmm.
Does the new owner have to honor that lease?
So that's going to depend on how the lease is worded, because a lot of times the lease will actually say, if it's a well-written lease, that it can pass to successors and assigns from the landlord. It's going to depend on if the tenant is current on their rent at the time of the purchase. It's going to depend on whether the buyer and the seller negotiate that. A lot of times, if it's not in the lease, and most leases probably don't have it in there because that's not typically something that a landlord is thinking of when they draft the lease. A new buyer is going to come in, they'll introduce themselves to the tenants, and this is the rent I'm going to charge. Take it or leave it. It's up to you.
I thought all leases conveyed with the sale. I thought if you had a lease in place, it conveyed, like I thought.
Not necessarily. It's going to depend on the context of the lease. And most of the time, practically speaking, it's easier for the buyer to just have it conveyed over because you already have a rent-paying tenant. It's a good investment, and a lot of this stuff, a lot of that information too, is in the estoppel affidavits that are provided for the tenant's information.
Could they change the amount of money that they're charging them though?
It depends. It depends on how the lease is worded. Yeah. If say you have a lease that ran to October 1, the sale happened, late last week. It's November 1. The lease is expired. They can change the terms because it's an expired lease.
But what if it has a year left?
If it's got a year left and the terms of the lease will allow it to convey, then no, you can't. You can't. You have to go by what's contained in the lease to raise the rent, just as you would if you've been the landlord for 10 years.
So that lease that when they bought it conveys, and they have to pay that same amount for the year, even though it changed hands.
That's correct. If the lease conveyed, that's correct.
Okay.
So if your lease is going to contain a provision that will control the conveyance, that's very likely it's a well-written lease, and it will also have a clause that talks about escalation of rent. Generally speaking, and I'm talking generally, I don't have a particular lease in front of me. These leases will say if there's going to be an increase in rent, you need to give the tenants a 60-day notice, and that is not done unless your lease is worded very crazily. That's not done during the term of the lease. That is typically done 30 days, 60 days before the expiration of the lease. And then that new rental amount that's the controlling number that's used in the next term lease. Does that make sense? Well, I'm here for you. What are you confused on? What can I help with? Clarify.
I always was under the impression that the lease conveyed, but just go ahead, because I know people have a lot.
No, it's fine. It depends on how the lease is. It
If it's not
depends.
stated, what would they say? It's not stated one way or another.
So if it's not stated, then that's gonna depend on how it's negotiated between your buyer and seller. If they want to accept it, then that's fine. If the buyer doesn't want to, that's their prerogative.
So what would the process be then, if your client or your current tenant, if you're the seller, right? And you're go under contract, and then the buyer says, I don't want either, and say your tenant has a 2-year lease left, what process do you have to do? Say you have a 30 or 60-day close, what is the eviction process then, if that doesn't?
So at that point, that's kind of when practicalities are gonna step in, because rather than looking at it from the landlord's perspective, that's where you kind of have to flip the script and look at it from the tenant's rights perspective. So in the event that you wanted to just perform an eviction, I don't want this lease, I'm the buyer, I'm just gonna do my thing. Well, the tenant's gonna have a lot of defenses to that. So that's when you start really getting into the practical reasoning behind just conveying the lease. Because as simple as it could be, okay, I'll accept this lease at conveyance or I won't, that's fine, but you still have to go through the eviction process in the event that you opt not to. And those are very valid defenses for a tenant if you have an active lease.
Yeah.
So it's, you gotta look at it from multiple angles, if that makes sense.
I'm
Yes?
really gonna irritate you with this.
No, I'm here to help you guys.
What
It's
if,
not-
if they wanna buy it and live there themselves, like say it's a single family and they've got a lease, these people have lease, but then the owners are like, you know what, we don't wanna deal with rentals anymore.
Sure.
They go to sell it, the new people, the buyers are like, we wanna live there, what happens then?
Virtually all leases that I've seen, unless it's like your one page off the internet type lease, virtually every lease has a clause that's gonna control that. Typically speaking, the landlord does have that right. If you have an active lease, that is part of the lease where the landlord can make the decision that they're going to occupy the property. But you can't just have the landlord say, well, I'm gonna occupy the property, evict them, and then the next day, I don't wanna do that. That's not gonna work either, because then that's gonna put the landlord, that gives the tenant claims against the landlord, and the landlord's gonna be sued, and the landlord's probably going to lose. So you add this circles back to the good faith and fair dealing. If the landlord legitimately wants to move in, that's the no fault eviction. And that 99 times out of 100 will be controlled by the terms of the lease. Yes?
You just answered my question. So that would have to be part of the lease that says if the owner or new owner wanted to occupy the property, then they have that.
If it's an active lease
Yeah.
that's conveyed, yes.
Yeah, okay.
Yes, sir.
As a broker, I've heard all of these questions before. I'd like to refer us back to the beginning. Do not give legal advice.
Yeah, let me and John, we'll figure it out for you guys and try to make your job easier and also make you guys look like superstars to your clients too. We don't lose sight of that. When you guys direct a question to us, part of my job is making you guys look like you walk on water. So it goes both ways. So I do appreciate that though. Thank you.
But
Yes.
Brian, that puts it back on a tenant, may not be able to afford legal counsel
Mhm.
in many of these kind of situations. That, they may not have understood that the lease that they signed didn't have conveyance
Mhm.
written in. Should they be guided to, what type of legal counsel?
So typically in that situation, I'll give, if I'm speaking to the tenant directly, or if the agent needs to give contact information to the tenant, two really good sources for a tenant who can't afford counsel. There's Rhode Island Legal Services.
What was it?
Rhode Island Legal Services.
Okay.
I used to know their number off the top of my head, but if you just Google Rhode Island Legal Services, they come right up. And there's also the Rhode Island Lawyer Referral Services.
Okay.
That's through the Bar Association. The Bar Association does have programs to where they have attorneys who are in the private sector who will take on pro bono cases to assist in situations like that.
Thank you.
I can tell you from experience, Rhode Island Legal Services, although they will represent, the lower income tenants for little to no payment, you are not getting discounted representation in terms of your quality of attorneys. There's really, really good attorneys with Rhode Island Legal Services. People I've known for a long time and respect, and they're outstanding attorneys. So even if the tenant can't afford your $300-400 an hour attorneys out there, which, I mean, let's face it, especially nowadays, not a lot of people can do that. They're still going to get outstanding representation. So be confident every time you have to give that referral out. There's some really good folks in that office. Any other questions for now? Okay, all right, we'll move through here. If you want to advance to the next slide, John, if you don't mind. So there's 4 different main types of tenancy, and this is where we're going to get into the squatters situation. There's a term of years, which is basically if you're on a year-to-year lease, 5-year lease, depending on how it's set up, kind of common sense in terms of that term of years. Periodic tenancy is a tenancy that's established for periods of time. And I know that sounds confusing, but a periodic tenancy can be a term of years. So you can have a periodic tenancy of year to year. You can also have periodic tenancies of month to month. You can even have them week to week, depending on the situation. So a periodic tenancy is a little bit broader than a term of years tenancy. A tenant at will is a situation where you have someone with the permission of the landlord that's occupying a dwelling unit. There's no rent that's being paid. This is just an accommodation to the tenant from the landlord. They have express permission to do it. But at that point, that person can also be evicted at any point. And when I say that, I don't mean tomorrow you're gone. You have to go through the court process to do it. But that is a type of tenancy that's recognized under Rhode Island law for an at-will tenancy. There are certain statutes that govern an at-will tenancy in terms of the type of notice that needs to be sent to an at-will tenant. But right now I'm just trying to explain the different types of tenancies that exist under Rhode Island law. Tenant at sufferance. This is generally where your squatters are going to fall in. The definition of a tenant at sufferance is someone who previously had the right to occupy a dwelling unit or a house unit, whatnot, but no longer has that right. So right now, you're all probably thinking a squatter never had that right, right? They're here now, but they never had the right to occupy it. But the problem is we circle back to what I was mentioning earlier in terms of proving the fact that the squatter never had the right. So they're going to come up with some excuse, whatever it is, legitimate or not, as to why they're standing in that unit right now. But now they don't have the right to be there for one reason or another. That could be their lease expired. That could be they're not paying rent on an expired lease, which would be a periodic tenancy, because when a one-year lease, for example, expires and you don't have another written lease for another year, generally speaking, those leases they go month to month after that. Tenants at sufferance. I mentioned earlier that the Landlord-Tenant Act is Title 34, Chapter 18, and all the subsections in Rhode Island law. Tenants at sufferance, that's a completely different type of eviction. That's actually governed by a completely different set of statutes. It sounds the same, but it's Title 34, Chapter 18.1. Point 1 makes a gigantic difference because it's typically a quicker eviction process, but that's also going to provide the landlord more of a burden too, because you have to prove to the court, this person's a tenant at sufferance, they're not a normal tenant, this is why I'm fast tracking this. So that is really going to come out when you're doing questions in open court that the judge wants on the record. But proceeding under the tenant at sufferance statute is not just a willy-nilly decision that's made because it's quicker. You have to be able to substantiate why you're going that route. Does that make sense? And that's, like I said, Section 4 here, the tenant at sufferance, that's where your squatters are going to come in. They're not going to get your 60-day notices like a lot of the other occupants because they're not going to fall under the Landlord-Tenant Act. But they still are entitled to a notice. Under 18.1, the court They deem the amount of time on a notice as quote-unquote reasonable, which, helpful, not helpful? It's not really defined under case law or statute. Some judges will accept a 7-day notice. Most, in my experience, which is how post-foreclosure evictions used to be done in the state, they'll accept 14 days. Most courts don't have a problem with 14 days. But at a minimum, that's what you're looking at for a tenant in sufferance. That's before you can even file your complaint. Yes?
What kind of tenant would be a tenant that didn't have a rental agreement or lease agreement? Just, you know, you knew them or you got referred to you, you rented them an apartment. What kind of tenancy would that be?
That could be a situation where you've got a conveyance of title of property, but not the lease, on an expired lease. So your buyer comes in, you've got a tenant on an expired lease. They're not paying. They're not under any kind of rental
What
agreement.
if you own the property and you have somebody living there and you didn't want them to be there anymore?
You're going to have a much more difficult time terming them as tenants in sufferance. You can say, yeah, they overstayed the lease. The lease expired on October 1. They're still there.
I mean, which rule would you use? The term of years, the periodic tenancy,
So
eviction process?
in that situation, if you're the landlord, you have somebody that overstayed their lease and they're not paying, it would be the periodic tenancy, because that would by operation of law, that lease would convert to month to month, and then you'd proceed with a non-payment. And you can mention when you're in court as the attorney that these people are tenants in sufferance, they shouldn't be there.
No, I
Hope,
was just asking a
yeah,
personal
right.
question.
But I'm just saying you can mention that to the judge and kind of hope that gives you a little bit more of a fast track to get it done. But in terms of the notices and the mechanics to get it to court, you'd want to go under a periodic tenancy. Yeah. Yes.
Question, what about college housing? Because let's face it, I mean, that's fine, Narragansett to change their rules. If there's some kids that are out of control in the housing, what do you consider it? Because usually those kids have like a lease from like September to May.
Yep.
What would that be? Is
So
that periodic or?
Well, this is just the type of tenancy. I think what you're driving toward is more for a cause reason to evict. We're going to get to that. I have a list for you of all the different quote unquote material breaches of leases that would kind of qualify under that. So hang tight for just a little bit, and I'll give you that whole list, which I think it'll help make it'll make it clearer. Yes.
I had a friend who had a tenant. The tenant invited her mother and brother to come stay. The tenant moved out. The mother and brother would not move out. They weren't on the lease, so they were squatters, I guess, and it took them 9 months to get them out.
Sure. Yeah. It can be a nightmare. Depending on the route you take in terms of how quickly you terminate a tenancy, you can do the material breach, you can do the cause being they're creating damage. The legal term for that is they're creating waste, which basically just means they're damaging the property. But again, you get to a point where you have to weigh how quickly you're doing it versus what you can prove. So it's all a fine balance. In that situation, be it the landlord or the attorney if they retain one, may have terminated the tenancy properly. Everything was fine. You get the complaint in front of the court. There's a million different reasons why you can slow track from there. The tenant can file an answer. They can file a counterclaim for code violations. Even if you're a squatter, well, probably not a squatter, but if at some point you had the right to be there legitimately and there's code violations, that can slow an eviction down. You start getting the town and the municipality involved. You start getting inspections out there. Then you're dealing with potential inhumane living conditions. In that situation, a lot of times the judge will actually order the landlord to put the tenants up in a hotel until the remediations are done. And I know that sounds ridiculous. I've seen that, not in Rhode Island so much, that happens all the time in Massachusetts. And that's actually another point too. I'm focusing this presentation on Rhode Island law. I know some of you do Massachusetts too. If there's a quick question that comes up in Massachusetts that you're dealing with practically, feel free to ask. I just don't want to spend a lot of time on Massachusetts law because it's a completely different process. Much slower than Rhode Island.
I'm sorry, one more question.
Sure.
No. In that situation, is that breaking the lease if she had people come and live there that didn't belong there.
Usually, yes. If it's a well-written lease, absolutely, it'll
And so
govern that
that could have
situation.
been, they could have said at the time,
I go after her, but she
Yeah.
wasn't the problem.
Right.
Still couldn't get them out.
yeah, but if they, cause going forward, people are probably gonna be thinking of things like this.
Probably thought it was okay, they were coming for a visit, probably said, fine, and
Yeah.
then she usually.
Yeah, you're not watching the place, you don't know they never left.
And I see I'm starting to get a little short on time, so I'm gonna speed things up from an overview standpoint, because I still wanna give everybody an option for more questions and answers. Maybe you have a question that's not kind of fitting the presentation, so I wanna make sure you guys all have time for that too. So John, if you could just advance quickly, go back, if you don't mind. So these are the different types of evictions that you can do. You got your standard non-payment that everybody's familiar with. Non-compliance, which I'm going to give you the list of material breaches of the lease. Termination, or that could be a variety of reasons. That could be the no fault that we were discussing earlier, if a landlord wants to move in. Non-renewal of lease. Crimes of violence, narcotics nuisance, those typically will fall into the non-compliance of the breach agreement. And again, I'm going to give you guys a list shortly. I just want to kind of go through this at a higher overview now. I'm so wordy, and I'm sorry. I'm taking up so much time on some of this stuff. I'm gonna try to go more quickly for you. If you could advance, if you don't mind. This is, I could literally talk about, I could probably teach a class in school about the entire process here for Rhode Island evictions, but just to get through this, this is generally speaking the very straight line, no complicated process for Rhode Island eviction. I guess point 0 would be your notice to quit, which is what terminates the tenancy. You then file a complaint. Once the complaint is filed, the clerk's going to issue a summons. Depending on whether you're doing non-payment of rent or if you're doing breach of the lease, whatnot, that's going to dictate how much time a tenant's going to have to file an answer with the court. Sometimes it's 9 days, at least the way it used to be with the non-payments. For evictions other than non-payment, it's a 20-day process. So that's from the date they're served. Can't do anything for 20 days. So they have 20 days to file an answer. Once that time period expires, then you can, well, I'm getting ahead of myself, I'm sorry. The tenant can also file for discovery requests, which generally speaking is an exchange of information between the parties. If the tenant is claiming there's no lease involved, they can, with their attorney or through themselves, can file a request asking for a copy of the lease. Basically all the proof that you have for why you're filing a complaint. There's pretrial motions that go through. For example, if no answer is filed after the time period expires, we file what's called a motion for oral proof of claim with the court. And once we file that, the court will then send notice to all the parties as to their court date, which is usually 2 to 3 weeks out, generally, from when that motion is filed. So already, we're looking at almost 60 days in. We're not even in court yet. This is just how this process works. You've got your court hearing. The court will then issue a decision, and then you can have post-judgment motions too. Post-judgment, for example, say the landlord prevails and the court grants them judgment. The next thing that happens is an execution will issue. The landlord goes to give that execution to the constable, sheriff, and the moving company to do an actual lockout. The tenant can go into court and can file an emergency motion to vacate that judgment for whatever legitimate or whatever reason they think it would be valid for that to be granted. They can file an emergency motion to stay the execution, asking the court for more discretionary time. So there's a variety of additional motions that can be filed even when you think you're at the finish line. It's not quite there yet. From the date of judgment, a tenant has 5 business days to appeal. If they appeal, it goes from district court to superior court, and it's essentially a brand new trial. That's just, none of the evidence from the lower court comes up to the superior court. It's called a de novo review, which in Latin just means new. And so it's a brand new trial in superior court.
Does that happen often?
Depends on the situation. Maybe 10% of the time. Most of the time, it's really just to buy more time. Is really the kind of thought process there. But usually, you'll get a hearing date in superior court, 30 days, maybe 40, maybe 45 days from the date of the appeal. And again, you're starting the process over in terms of getting yourself a hearing date. Then you gotta get the judgment from Superior Court. And then you have to get the execution from the Superior Court, which again, you've got the 5-day deadline. One thing that doesn't come up very often, but it's worth mentioning, in the event that a judgment enters in favor of the tenant, plaintiff, the landlord, only gets 2 days to appeal. So a tenant gets 5 business days, a landlord only gets 2. So that's, again, that's not gonna come up very often, because most of these are pretty straightforward, but that is something that I thought might be worth mentioning. But again, that's one of those technicalities to where you might not remember that, which is all the more reason to direct a landlord to an attorney, so that this can be explained to them. John, if you could just advance if you don't mind. This is the slide that I really wanted to make sure I hit before we do the Q&A. This is one of the things that's going to directly impact your day-to-day lives. I'm sure you've all seen all or some of these at some point. You've got security deposit transfers, disputes that come up, fair housing laws that have to be complied with. Fair housing laws, whenever something comes up that might even sniff of some sort of discriminatory element, make sure you get your attorney involved. There can be very, very harsh penalties if a landlord takes any kind of steps that discriminate against a tenant for any variety of reasons. And again, that's kind of common sense. I mean, all of us know you don't want to discriminate against anybody for any reason. But your clients, and I'm not trying to badmouth any client, but they don't necessarily understand that. They're all thinking, I need this house vacant, I don't care. And just make sure your clients don't put you in a bad position and try to kind of force your hand when you're trying to service them. This is another one of those red light things that should go off anytime anything even sounds like discrimination. Get an attorney involved, run it by an attorney, just to protect yourself, protect your client. There can be source of income issues, I'm sure that you've all dealt with. That kind of stems to the next point, which is estoppel certificates. Is the tenant timely paying their rent? Is the rent fair market rent? Is that being factored into the buyer's loan in terms of their affordability of the house? These are all things that you all think about anytime you're representing a buyer. It's all, again, common sense. But this is all stuff that kind of, it's within the eviction realm, that it's all interrelated. The last part, this is something you've all probably dealt with, at least tangentially, but this is kind of more of an attorney issue, is covenants running with the land. Mainly, for purposes of this presentation, we're looking at affordable housing properties, Section 8. Section 8 has a whole different type of regulations that are required if you're going to do an eviction, for the way tenants' leases need to be worded, for the terms of the tenancy. Because Section 8 is a federally subsidized program. So you're not only dealing with Rhode Island law at that point, you're also dealing with federal law. So again, it's just another set of complicating factors you just want to make sure that you're on top of and aware of. You know, I'm doing my best not to overload you with all this, hopefully not overwhelming information to try to remember. But my hope was that kind of by doing this presentation, I'm at least helping make heads or tails out of some of the common questions and situations that you guys are seeing day to day when you're out there and talking with your clients. Does anyone have any questions, any hypotheticals that you're dealing with that I can help you with, or that I can maybe help point you in the right direction? Anything that can, yes?
Let's say you have a landlord who has a tenant who misses a payment.
Mm-hmm.
I've heard advice in the past of have that person file, or have they file the eviction notice almost immediately, just to get ahead of the ball. Do you agree with that, or do you agree with them waiting to file an eviction later on?
It depends on their relationship with their tenant. Because depending on what the landlord's going to do, that's going to directly impact their relationship with that tenant going forward. If the landlord has a really good relationship with the tenant and they think it's a one-time thing, even as the attorney, I'd probably say, why don't you work something out? And if you don't get paid next month, why don't we consider it? So if you're gonna proceed with a non-payment of rent eviction in Rhode Island, the landlord sends out, it's a 5-day demand notice, but the rent has to be at least 15 days late before they can do it. So if they're 5 days late, you can't do anything until that 16th day. And if that timing of that calculation on that notice is wrong, if you send it on the 15th day instead of the 16th day, that is what I mentioned earlier, a jurisdictional issue. You bring that to court, the judge is going to look at it. The judge is going to say, hey, this notice was sent out early. I can't even hear this case. You could be dead on the money in terms of having all the evidence in front of you. Can't even hear the case. Dismiss, try it again, and make sure you comply with the statute. But yeah, I think the answer to your question, though, it's all going to depend on the relationship between the parties and how they want to impact it going forward. Yes?
If you had an eviction, they were supposed to be October 1st. It was filed in the end of August, they're supposed to get out October 1st. They said they had a place to go, so you kind of let them go. And now they're still there, and we're in November now. Do you have to start all over with that eviction,
So-
or just now?
I'm not really following your question, just in terms of the details, because the detail will matter on the next step. So when you say you've got an eviction, you go to court and you agree to October 1st? Is that what you mean?
Yeah, they were served, they were
Yep.
going to be out October 1st.
In court, they agreed to that.
They never went to court, they just accepted the letter and.
Oh, so they got a notice to quit, and it said vacate by October 1st?
Yes.
Okay, so what happens there, regardless of the tenant's intention, the landlord can then file a suit on October 2nd, if they're still there. And that's a good way.
But if the landlord let it go because they said they were gonna be out in a couple more weeks, and now here we are in November.
2-week delay, that's not gonna make a difference. So you're saying if the letter said October 1st, the
It's not-
landlord
it's not
decides November 1 to file a complaint, that's fine. Because a lot of times too, that can be indicative of the parties trying to work something out. And if you can't, then you avail yourself to the court, let the judge make the decision. Excuse me. When you start getting to a situation where you're like 3 months beyond the date, 6 months beyond the date, you want to kind of gauge whether a court's going to look at that notice as being stale or not. 3 months would probably be in that gray area for me. I'd really have to look at it on a case-by-case basis to recommend whether a new notice should be sent. 6 months, even like in post-foreclosure evictions, when I'm representing a bank, I'll tell them that's not going to work. You're going to need to send a new one. It's stale.
This was a family issue, trying to get a family member out.
And that's why a few weeks, even a month, is reasonable, because the judge understands that a lot of people want to try to work this out without needing to go through the whole eviction process. Which typically, you don't have a social security number that's attached to an eviction complaint, but that's a public record. So when you're a tenant and you're listed as a defendant in a complaint, future landlords are going to see that, and that's going to raise questions. So usually you kind of want to balance that. And if the judge sees that the parties are being reasonable and trying to work together, that they're not going to mind if you're a few weeks late in terms of filing a complaint. Yes?
So I don't know if you can answer this question, but that scenario there, let's say the property was for sale and they, the agent wanted to show the property, can they demand that showing?
That's generally speaking going to be a clause that's in a lease. Most leases that
But
I've
if they've been evicted or they're through that,
Oh, so you're saying you've got a judgment, you just haven't physically relocated them yet?
Yes.
At that point, I tell the landlord, just wait. Because what's going to happen then is if you have an eviction judgment and you're days away from doing performing a lockout, which is legally speaking called levying the execution, at that point, what you're going to do, regardless of whether it's within your right to send a 48-hour notice for a showing, all you're going to do is inflame the tenant. So at that point, what is a tenant's motivation going to be not to completely trash the place and cause more damage to the landlord? So that's more, you're getting kind of away from legally what can I do versus what should I do, if that makes sense. Yes?
Going back to the 5-day demand letter, what's the amount that you can go after, that you fill in, that they're behind? Because I've heard 2 different scenarios. So pet fees, rents, late fees, just rent.
Whatever is included in the lease, whatever the lease says you can go after. I typically, in situations where there's a 5-day, as the attorney, I don't sign on behalf of the landlord because the landlord is going to be my witness in court. And if I sign the notice, I'm potentially making myself a witness. So there's a conflict issue there. But I'll draft notices for landlords to send out. I will say $900 a month, $1,000 a month for rent. They're behind for 2 months. So I'll say as of the 16th of November, you owe $2,000 plus separated out $50 in late fees. right? And then I don't say for a total of, I just separate them out. And what's going to happen is when you get that in front of the judge, at that point, the judge will determine, does he or she just want to award you rent? Are you afforded the late fees under the lease? Is it something you just thought that you could get away with? Because then that's going to be chopped. So it's really, the true answer to your question is whatever the lease allows, separate it out though. That's the best way to do it in my opinion.
So I've had other attorneys throw it back, that it can only be the rent. I've had others say, no, it can be the rent plus the late fees.
That's why you want to. That's why you want to separate it out.
Okay.
That's the importance. You don't want to do a lump sum that's going to include late charges
So
or
as long as
fees.
it's itemized.
Right.
Okay.
And I've had good experience doing it that way. And at that point, the judge, if they say they're not entitled to late fees, okay, get rid of it. Store the back rent. Yes, sir.
There's been a lot of new laws being introduced in legislation. How is that going to impact the eviction process?
So I think that's generally, it's more in terms of streamlining how the court's going to handle it. It might streamline it in the sense of making it a quicker process, because typically, especially evictions that are for non-payment of rent, they're generally termed summary process, which is, it just legally is for saying it's supposed to be a quick process. So I think the thought process is, there might be more mandates on landlords saying you have to dot this I, cross this T before you can terminate. But I think the thought process is to just make it more streamlined and hopefully remove some ambiguities. Yes?
So when a landlord gets a judgment against a tenant, they have to move out, but they never pay. What do you do then, go back to court?
So in the event that you have a money judgment for back rent.
Right.
Yep, so it's kind of bifurcated. So you've got your judgment for possession, and if you've ever been to court on one of those, the judge is very, very poignant in terms of delineating these two. Possession is that allows the landlord to get possession to a lockout. Then there's the money judgment for the back rent. If a landlord wants to go back and try to collect that, they can do that through the collections process. It's a supplemental process. It's the same way a debt collector would try to collect on an old credit card.
So how do you find this tenant that left, that owes you money?
So you can do skip traces. You can hire private investigators to try to find these people. In my experience, even with private non-bank landlords, nobody does that. Because what happens is that's an unsecured debt. So if you get a money judgment for $5,000 and the tenant has no money, they file bankruptcy, they get a discharge, it's gone.
Right.
So it's practically speaking, it's kind of like throwing good money after bad, unless it's a substantial term that you have reason to believe that you'll be successful in collecting. It's not worth the time and aggravation, because most of the time the motivation to collect that is personal, and you have to kind of take a step back and understand my personal, you know, I don't want to say hatred, but my personal animosity toward this person, right? Is it worth the time and expense I'm going to pay someone to essentially get nothing? And most of the times when you really kind of sleep on it and think about it, the answer to that is no. Yes?
2 questions.
Sure.
Where does the adult child fall into all of this that won't leave a house? And mediation. Do you offer any kind of mediation services or?
Yes. Okay. So we'll go one at a time. The adult child is going to be the same as the
Squatter.
not quite. So it's like a sublessee, but not. They don't have a sublease. They'd be treated just like the hypothetical earlier about moving the mom and sister in. Same deal.
Okay.
And if they're over the age of 18, they need to get their own notice to quit to terminate their tenancy, because they do have rights, and they have to be named on the complaint and on the execution if you're going to perform a lockout. If a sheriff or a constable goes, mom's name is on the execution, but the 20-year-old son or daughter is not. That lockout's not happening. You got to go back in, amend the complaint. You got to get their name on it. You got to make sure that they're properly served, that they have their opportunity to do process. And then once that's complete and you have judgment, then you can move forward. Okay. And your second question, I'm sorry, can you refresh me one more time?
Mediation.
Mediation, yeah. So most times in court, especially in Providence, there's actually mediators, the part of the court program. They'll actually give a spiel before the calendar is even called. Oh. Typically, when there's pro se landlords and tenants, the judge refers, as far as I know, every one of those to mediation. If I'm in a situation where I'm representing a landlord and I've got a pro se, Most of the time, I don't need a mediator because my approach, and I think most eviction attorneys' approaches, are to go out in the hallway, try to work a resolution, because that is usually the best case scenario for all parties. If the other party is intimidated just because of the fact that I'm an attorney, and I know I'm an intimidating guy, right? But just sometimes because I have ESQ at the end of my name, they're a little timid. That's fine. We do mediation. All that's going to do is serve to help. Whenever there's two attorneys involved, a judge is almost never going to order mediation, though. That's, if you can't come to an agreement by the time you're in court, typically the attorneys are just going to battle each other. That gets saved to the end. Most everybody's out of the courtroom by that point. The judge lets them do whatever they're going to do, and then make a decision one way or the other. Yes?
You mentioned several times a well-written lease. Do you like the Rhode Island Realtors lease agreement?
Yeah, I think generally speaking, that's a pretty well-written lease.
Okay.
Anytime that you have a sophisticated landlord or a sophisticated tenant that has certain items that they want included in the lease that might not necessarily be there, run those by an attorney. Make sure that it's in compliance with that the Landlord-Tenant Act, and you can kind of come up with your own form lease. But just generally speaking, you got pretty easygoing tenant, pretty easygoing landlord. That's really not a bad form.
Okay.
It's really not.
What
Yes.
if, I had a landlord tell me they had gotten a stick, so that the tenant could not appeal. They have 20 days and that's it, the judge is not gonna hear them again?
On paper, yes. Practically speaking, no. I've done many stipulations with an attorney on the other side, and they waive their right to appeal. 4 days later, there's an appeal. Nothing I can do about it. I've tried that, particularly when I was fresh out of law school, because I thought that held weight. And the judge kind of looks at me like, okay, cool, but we're here now, so let's do a trial. Okay. So that typically is not worth whichever party wrote it on the stipulation, because it's not really gonna hold water. Does anybody else have any other questions? I hope that you guys found this helpful and I wasn't boring everybody to death. Hopefully this was good information for everyone. Yeah, well that's the key, right? That's the key. I don't know how entertaining I was, but hopefully it helps.
Thank you very much, Brian.
Absolutely.
And Guild Mortgage for sponsoring us today. Thank you. My name, if anybody's unaware, is Anthony Amaral. I'm the chair for the Kent Washington Association of Realtors Education Board. And we put these on a monthly basis overall. We do, the survey was passed out to everybody too as well. If you fill that out, please, it helps us to do a better job on a monthly basis. There's also a spot in there if you have an idea for a future class. We put them and we'll discuss that. The board meets on the second Tuesday of every month. We always look for new members. Our next class coming up is smoke and carbon monoxide detectors and new laws on December 12th. You'll all be getting the updates soon in order to sign up for that class too as well. I think that's everything I have for the day. Everybody have a good Thanksgiving.
Grab a star before you leave.
And a star, don't forget stars.
Yes, drop into the
Don't forget
office.
star, in the office. Very good, thank you all.